So we've been talking a lot this hour about the fear of a changing America amid the mythology of a post-racial America. It's a myth that was reinforced this week when the Supreme Court upheld Michigan's ban on affirmative action in higher education admissions, ignoring its duty to protect the rights of the minority and ruling in favor of states' rights. In 2003, the University of Michigan faced 2 lawsuits challenging its right to consider race in admissions. Ultimately, the Supreme Court ruled in their favor, saying that the university could consider race among other factors in admissions. Opponents of affirmative action were not to be deterred, though, and in 2006, they were successful in passing a ballot initiative in which Michigan voters banned consideration of race by a 58% majority. After being struck down on appeal, the case ended up in the Supreme Court, and here we are today, with a majority ruling that essentially says states are free to pass whatever laws they want, even if it means trampling on the rights of the minority. Or, as an editorial in the conservative Washington Times said, quote, "The Supreme Court under Chief Justice John Roberts took what legal scholars are saying is one more step away from the concept of federal supremacy." But what about the court's duty to protect the rights of the minority, particularly when a law has a disparate effect on a group of people? Well, Justice Sonia Sotomayor hit the nail on the head, writing in a scathing 58-page dissent that the decision, quote, "eviscerates an important strand of our equal protection jurisprudence for members of historically marginalized groups which rely on the federal courts to protect their constitutional rights. The decision can hardly bolster hope for a vision of democracy that preserves for all the right to participate meaningfully and equally in self-government." Now, right now, 8 states have laws that affirmative action that the Supreme Court says is okay, and we expect more could follow. I'm going to bring my panel back in to discuss, and Judith, I'm going to start with you because, you know, there's so much in this case, I think, that is disturbing. I mean, obviously the notion that we don't need affirmative action, that we're colorblind and all of that, but also this idea of protecting the minority, that the courts are there to protect the rights of the minority.
Right. So at the heart of this case, you know, the decision really was not about whether or not affirmative action should change, right? It sets up some implications about what's going to happen in the future. However, what was important is that the court looked at the Equal Protection Clause. And basically, the question was whether or not you could create a different kind of political process. So let's say in Michigan, you allow actually the Board of Governors of the universities to make decisions about affirmative action. And you don't like that decision. The majority instead can then take it and put it as a ballot initiative, which means that the majority rules. Well, the Equal Protection Clause is supposed to step in to protect the minority from majority rule that hurts the minority. But the Supreme Court said, no. That's not the case. That should not happen. This is a democracy. Let majority win.
And the breakdown of that vote, I think, is very interesting. 63% of voters were white who voted in favor of it in 2006. About 14% were black. So that very referendum became a referendum about race.
And I think the majority, as I read, the majority of black folks who voted against it. Yeah. Absolutely. You know, Mike, the thing that I found interesting in the coverage of this that I found very disturbing, I mean, a lot of people were saying, oh, this is about reverse racism, this is about, you know, I mean, that was a lot of what we heard, and states' rights, right, and, you know, strengthening the rights of states, which is kind of another part of what we've been talking about today, kind of this federalism versus the rights of the states. But states' rights is a very old code phrase that has a very old meaning for a lot of people. It is, sure, and it's funny how states' rights somehow or another always ends up supporting one side against another side, and we know which side that is. You know, the Supreme Court has been doing this in many realms, and this is going to continue, and it is going to change the way affirmative action works in America in a very dramatic way. It already has changed at the level of the public schools, where I don't think there's been a more dramatic decision by this Roberts Court than that case in that Seattle and Louisville decision. It's resegregated schools all over the country, especially in the South, but now it's going to start happening at the level of higher education, and it's something that, you know, a culture working against that, and public education working against that, is going to have to work really hard to broadcast itself. And you know, Dorian, it's interesting. A man by the name of Edward Blum calls himself a one-man organization and challenges government programs that rely on race. And he actually was behind Shelby County versus Holder. So should we be surprised in how this all ended up? But he is actually in the process of trying to go to other schools to find other people, as Mike was talking about, to bring these kinds of cases and work their way up to the Supreme Court, I suppose.
Absolutely. This is an organized effort and he's not the only one, but this is an organized effort with a lot of money behind it. You know what I find so interesting? If we really lived in a post-racial America, folks like that guy, Ed Blum, he would be launching ballot initiatives against legacy admissions in universities that in many cases take up many more slots than the few people of color that are actually in these colleges and universities. If it's really about privilege and unfairness, why not target legacy admission? Oh, but wait, that's mostly white people because people of color are excluded for a few hundred years from most of our colleges and universities. So it just opens up, it just makes clear that this is really about racial retrenchment and racial fear, as Judy mentioned.
I'm just worried about the trajectory because if you're taking swipes at the Equal Protection Clause, you know, what protection do minority people have under the Constitution? We have an Equal Protection Clause for a reason.
But isn't part of the answer to that the culture is trying to say to us, or at least the court is trying? I mean, John Roberts basically said it in Shelby County. Well, a lot of black folks showed up to vote, so must not be a problem anymore.
That's right. Clearly, Roberts and Scalia say, get over it. I mean, Scalia says that the Equal Protection Clause is not about group rights, it's about individual rights. Hello? Why was it passed? Because of slavery, which was about a group, not about an individual. So, I mean, you know, it's really sad because we are headed in a really wrong direction. I think everyone should read the opinion of Justice Sotomayor. It lays out the history. It talks about why race matters today. She takes really good swipes at her fellow justices, but she lays out the law and why we should be very scared of the way that this court is headed.
And you know, Igor, the other thing, like, where does this stop in terms of using ballot measures as a way to get what you want?
Yeah, I mean, we see in Wisconsin already a push to make this very same thing happen in Wisconsin. But I think in Michigan, it's important to point out, I mean, this has real consequences. African American enrollment down 30%. No more than 18 African Americans in the Michigan Law School since this came down, since they can't use race anymore. So, you know, it hurts, I think, the student body in general with less diversity, but it also hurts African Americans. It doesn't open those doors.
Implications for judges. Who are going to be the black judges?
Yeah,
and the black
the Sotomayor,
and the prosecutors, and how are we going to impact not only who's going to be the black lawyers, but also the conversation that happens in a law school classroom?
Of course. You know, I think since we're becoming a majority-minority country, it should be all about, you know, proportionality, right? So you got to make sure that you represent the, you know, culture that we are, and not the sort of, you know, issues of the, you know, the wealthy few. But we shall see. All right, I want to thank my panel, Judith Browne Dianis, Igor Volsky, Dorian Warren, and Michael Tomasky. And that does it for me. Thanks so much for joining us, and I will see you back here tomorrow afternoon at 4 p.m. Eastern. Have a great night.